The Government Records section of the Department of Natural and Cultural Resources has created this video to help you understand the basics of public records. This video discusses public records laws as outlined in General Statutes 132 and 121. It discusses the regulations for destroying public records as found in the North Carolina Administrative Code. It also covers the regulations and considerations involved in determining how long to retain public records. Let's start with the basics. What is a public record? General Statute 132-1A defines public records as anything, regardless of physical form or characteristics, created or received pursuant to law or ordinance, in connection with the transaction of public business by any agency of North Carolina government or its subdivisions. This means that public records include documents, papers, and letters, but public records can also include maps, books, photographs, sound recordings, film, magnetic and other tapes, electronic data processing records, and even three-dimensional artifacts. As you can see, public records come in a variety of different formats. It is important then to remember that a public record's status is based on the content of the record, and not the form in which the record appears. Your paper materials, like a memo, letter, or report, and your electronic materials, such as your email, databases, spreadsheets, social media, or websites, must all be treated as records under the Public Records Law. In addition to providing the legal definition of a public record, General Statute 132 also outlines the reason that state employees must maintain the records of their agency. The statute reads as follows: "The public records and public information compiled by the agencies of North Carolina government or its subdivisions are the property of the people. Therefore, it is the policy of the state that the people may obtain copies of their public records." Sure, managing public records is an important function for all state agencies, but General Statute 132-1B specifically states that the records created by any North Carolina government entity are owned by the people. By committing to sound records management practices, you can ensure that North Carolina's citizens have access to the information that they need and want. Over time, though, many of the records that agencies create cease to be used. As a result, these records become unnecessary to retain. In other instances, records may not serve an immediate purpose for the agency, but they still have long-term value for the state of North Carolina. General Statute 121, the Archives and History Act, addresses these issues by regulating the destruction of public records and providing for the transfer of some public records to the state archives. Additionally, General Statute 121 designates the Department of Natural and Cultural Resources to assist government agencies with records management, including providing records retention and disposition schedules for agencies to use. The Records Retention and Disposition Schedule is the primary tool that state agencies use to authorize the destruction or transfer of public records. For more information about record schedules, see the series of videos on functional schedules for state agencies. Only about 5% of all records are archival. This means that about 95% of all records will be destroyed. The North Carolina Administrative Code regulates the destruction of public records. When used with an approved records retention and disposition schedule, records may be destroyed in the following ways. They may be burned, unless prohibited by local ordinance, shredded or torn up so as to destroy the record content of the documents or materials concerned, placed in acid vats so as to reduce the paper to pulp and to terminate the existence of the document or materials concerned, sold as waste paper, provided that the purchaser agrees in writing that the documents or materials concerned will not be resold without pulverizing or shredding those documents so that the information contained within cannot be practicably read or reconstructed. The Administrative Code also includes destruction of digital files. When used with an approved records retention and disposition schedule, the provision that electronic records are to be destroyed means that the data and metadata are to be overwritten, deleted, and unlinked so the data and metadata may not be practicably reconstructed. The Government Records section provides a sample destructions log to aid agencies in keeping track of their destructions of public records. The names for the records series, along with the required retention periods, can be found in the functional schedule for North Carolina state agencies. The date and method of destruction should be indicated along with the name of the agency employee who authorized the destruction of the records. Now that we know a little bit about the laws that govern public records, let's examine some of the basic characteristics of a record. All records exist on a seamless continuum that begins when evidence of an activity has been recorded. That record is captured in our normal record-keeping workflows and office activities. It is organized or perhaps cataloged for accessibility and use. And finally, it is placed within the existing framework that fuels collective memory and informs ongoing activities. Placement is typically the point at which inactive records are either destroyed or archived. Most records will be valuable to your office during their active and semi-active stages. This value may be for administrative reasons, fiscal reasons, legal reasons, historical reasons, or for any combination of the above. Let's look at some examples of each of these values. Administrative value, as the name suggests, concerns the day-to-day operations of your office. Examples of records with administrative value include procedural manuals, routine order forms, and memos. Fiscal value deals with financial information. Budgets, financial reports, and payroll records are examples of records with fiscal value. Often, records with fiscal value are subjected to audit. If an audit is imminent or ongoing, all records pertaining to that audit must be retained until after the completion of the audit, even if they have already met their minimum retention. If a record provides evidence of compliance with legal, statutory, and regulatory requirements, then this record has legal value. Examples include contracts or licenses. Much like financial records, legal records may be subject to official action such as an audit or litigation. If your office learns that some of its records may be used in an ongoing or upcoming legal dispute, these records cannot be destroyed until after the dispute has been resolved, even if they have met their minimum retention period. Finally, a record may have historical value and be deemed archival. Put another way, these records have ongoing or enduring value. These types of records document significant historical events and are often transferred to the state archives to ensure their long-term preservation and access. Assessing these values is called selection or appraisal. The archivist in the Government Records section consider the various values of the records in order to determine the length of time those records should be retained, based on legal requirements and on their current or potential usefulness. Archivists also consider records in the larger context of North Carolina's history, in order to identify materials that have sufficient historical value to be retained in perpetuity. To learn more about North Carolina's public records, visit archives.ncdcr.gov.